Let me ask you this.
Sir.
If I pulled a gun right now and stuck it to your forehead, what do you think's about to happen? What do you think's about to happen? I'm putting you in the position the victim was in.
Yes, sir.
You had all the authority and power, which you're not supposed to have over somebody. That's not for you.
Yes, sir.
The supreme being is supposed to have that power, not you. And if I put a gun, what do you think? The next moment, you can very well die. What do you think he thought? Same thing. You're going to later say, well, I didn't intend to kill you. How does that take back the fear and what was going through their mind thinking, I'm about to end my life on this as a living person is about to end, and I don't have control. Somebody else has control over my life, which isn't supposed to happen. That's not the way we're supposed to live, is it?
No, sir.
That's the way you did it. You assumed the power and authority. You can say, I didn't intend, but you think anybody believes that when they've got a gun to their head?
No, sir.
Yeah, that's going to make them feel better later. I mean, they'll wake up with nightmares their whole life. That's what they tell me. Well, that would be reasonable. It doesn't matter what you intended, it's what you did. That speaks for itself. I bet you didn't say, I'm putting this gun to your head, but I'm not going to really pull it. I don't intend to do anything to you. I'm just doing this. You didn't do that. You made them think they were about to die. You understand how that's terrible?
Yes, sir.
You had all the power, and that's not what it's supposed to be. That's not fair. He's asking for 10 years in prison, which isn't unfair. I bet you the victim kind of feels like, what am I supposed to do? I got to live with this my whole life. And he just gets 10 years. And then he's released. I'm the one that suffers my whole life. Okay. That seems awfully unfair. You're not supposed to put people in a position. But when you take out a gun and you point it at them and threaten them and say, what was taken from him here? What was taken from him? Searched his pockets, stealing about $800 in cash, a cash app card, and other personal items.
Good, Stephen. I wanted to say that actually no one took any money from him, but they did take someone did take some marijuana from him. I don't know what he actually told the detectives. I'm not aware. I never seen the paper of an indictment, so I don't know actually what happened. What he told the detectives, as I can remember.
How do you know? How do you know what was in his pockets?
I don't.
Well, why are you saying there isn't any if you don't know? He said to the police that there were $800 in cash they took. How do you know that he's not telling the truth?
Because after the robbery, no one had $800, sir.
Well, yeah. You were sitting there watching. Did you see them pull his stuff out of his pants?
I did.
Did you?
I was watching him. No one went into his pants.
Sir?
I shot, yes, sir. I was watching him. No one went into his pockets.
Well, where'd they get the marijuana from?
He had a bag of marijuana.
Where?
He got it from the trunk, sir. From the trunk of the car.
How did y'all get it?
He handed it over, sir.
Huh?
He handed it over.
At gunpoint?
That was actually before gunpoint. He was actually selling.
Wait. So what did you take from him at gunpoint?
That's what I'm saying. They actually didn't take nothing from him because they had an officer doing a patrol.
No, you had the gun to them.
Yes, sir.
Well, what did you get from him?
That's what I said. I told the probation
you just
officer,
pulled a gun to somebody who didn't have anything to give?
Sir, what I told the probation officer when she came to see me, that when I pulled the gun to demand the money back. I had a police officer doing a patrol.
Wait. What money back?
The money from the gambling. The money that I cheated out of. I demanded it back. someone screamed and said the police right there. We turned around, we seen the police cruiser. Everybody left. Everybody took off running. No one never handed the money over.
You put a gun to, what did you put it, to his head? What?
No, sir, just in front of us. Like,
What do you mean?
at chest height.
You mean to his chest?
Yes, sir.
Oh, okay. Well, that kills somebody, right?
Yes, sir.
Okay. And you were there to steal his money. To steal the money. To take it from him at gunpoint, right?
Yes, sir.
You don't see anything wrong with that?
I do, sir.
Okay. Anything else? No. Your criminal history, as it looks like you had an unlawfully carrying a weapon charge in Harris County, that was dismissed.
Sir.
And then it looks like you have an evading arrest or detention, a Class A misdemeanor pending over there, right?
Yes, sir.
Okay. Felonies, this is the only felony, correct?
Yes, sir.
Yeah, you can talk all day long about what your intent was, but you know, when somebody has a gun to their chest and there's nothing they can do, they're defenseless. You have all the power. They'll think of that their whole life. That'll be in the back of their mind forever. It's what haunts people forever. It's a nightmare that they have to live with. You understand? That's what you did. I mean, that's the punishment. I mean, that victimizes them forever. They just don't forget it. All right. Well, I'm going to find that you were pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. I am going to follow this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time served.
Comment your opinion, like the video, and subscribe for more real courtroom moments.
The court convened to address an ongoing property dispute between Mr. Kalani and Mr. Smith. The matter focused on whether the defendant had properly complied with a prior court order requiring the removal of a portion of a fence to restore access to the rear of the property. At the start of the hearing, the judge confirmed that newly submitted photographs had been received and shared with both parties' counsel, including attorney Mr. Friedman. The discussion quickly turned to whether the defendant had fully complied with the court's earlier ruling. Counsel for Mr. Kalani argued that although the defendant technically complied with the court's order by removing several fence slats, the action did not satisfy the spirit or intent of the ruling. According to the plaintiff's position, the purpose of the order was to restore long-standing access to the backyard area, access that allegedly existed for approximately 90 years. While 10 wooden slats had been removed as directed, the plaintiff maintained that a chain-link gate and post still obstructed the area within the 20-foot section the court had ordered to be cleared. Because of this remaining post, they argued that vehicles or equipment would still have difficulty entering the backyard. The judge examined the photographs and questioned how the remaining post actually prevented access. The court emphasized that the primary issue in the case had always been unimpeded access to the rear of the property, not necessarily the total removal of all structures in the vicinity. From the judge's perspective, the remaining gate post did not appear to block entry into the backyard. The defense countered that the structure in question was not simply a fence obstruction, but part of Mr. Smith's driveway gate, which he had the right to maintain in order to secure his property. And defense counsel also explained that when the contractor removed the ordered section of fencing, it became clear that the gate post was separate from the wooden fence and was necessary to support the gate itself. According to the defense, the removal of additional fencing would not meaningfully improve access to the backyard and could potentially interfere with Mr. Smith's ability to secure his property. During the hearing, The judge referenced a personal visit to the site and described attempting to maneuver a large SUV in the backyard area. Based on that experience, the judge concluded that vehicles could still turn and access the space without significant difficulty, suggesting that the remaining post did not create a true obstruction. The plaintiff's attorney also attempted to raise concerns about alleged harassment and hostile behavior between the neighbors, including accusations that one party had made threats. However, the judge immediately declined to entertain those claims within this proceeding, emphasizing that such allegations were unrelated to the property dispute and would fall under criminal or separate legal matters. Returning to the central issue, the judge determined that the defendant had complied with the exact requirements of the court's previous order. Although the plaintiff argued that the remaining gatepost violated the intended spirit of the ruling, the court found no new evidence showing that access to the backyard was actually blocked. The judge acknowledged that there may have been some misunderstanding earlier about whether the gatepost was attached to the wooden fence. However, after reviewing the earlier photographs and the current situation, the court concluded that the defendant had removed the required fencing sections as ordered. As a result, the judge ruled that no further action would be taken at this time. If the plaintiff believed additional relief was necessary, such as relocating the gatepost, they would need to file a new motion for the court to review. Without such a motion properly before the court, the judge stated there was nothing further to decide. The hearing concluded with the court affirming that Mr. Smith had fully complied with the existing order. So while leaving open the possibility for future legal motions should the dispute continue.